Hi there, my name is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to answer a question that was posed to me by a woman named Patricia on my YouTube channel in response to my request for questions. I put out a video a few days ago where I asked people what's their most important question about Social Security. I got a lot of great responses, and again, one of them came from a woman named Patricia, and her question was, why do Social Security judges ask so many questions of the vocational witness, and especially why do some of those questions document or express capacities that are way beyond what I really have? What is the judge trying to do, and should that make me concerned? And I think what Patricia's getting at is if you go to a disability hearing, most of the time the judge will have a vocational witness there. The vocational witness is there not to help you or hurt you, but to answer questions for the judge to evaluate whether you have the capacity for work. And so after taking testimony, the judge will turn to the VE, vocational expert, and say, Mr. VE, Ms. VE, I'm going to give you some hypothetical questions. I want you to assume a hypothetical or pretend person, the same age, education, work experience as our claimant. I want you to further assume this individual is limited to light work with the following additional limitations. Then the judge might go through additional limitations. This person needs to avoid work that involves climbing ladders, ropes, or scaffolds, no kneeling, stooping, crouching, or crawling, occasional ramps and stairs. This person needs to limit overhead reaching with the left upper extremity, non-dominant, to occasional. This person should avoid pushing and pulling, is limited to rarely. And again, they can go through just a whole laundry list. I've had hypothetical questions at hearings that can go on and maybe include 15 or 20 different considerations. And sometimes the judge will ask 5 or 6 or 7 of these questions, and one of them might be, let's say an example where somebody has serious back problems. The question might talk about this person's limited to light work, simple entry-level type of work, no ladders, ropes, and scaffolds. Could this person do any work, with no mention whatsoever of pain, or no mention whatsoever of depression, if that's an element there? And I think, and ultimately, one of the questions the judge asks, logically, will be what the judge adopts as his or her decision, if you will, about what your limitations are, because obviously they're talking about you. But if you have 7 questions, one of them reflects what's in the judge's mind, 6 of them do not. So why would a judge do this? And the answer is that the judge is really trying to figure out how close to the line he or she needs to get in order to approve or deny your case. Obviously, when the judge hears testimony, before asking the questions, 99% of the time he or she has made up his decision, made up his or her decision about whether you're going to win or not. So now it's got to be supported by a hypothetical question. So one question may not include any reference to pain at all. And so it's kind of a baseline that yes, there are jobs you could do. Then what if it was a moderate level of pain such that you could do work, but you would need to be limited to 1 or 2 step entry-level type of work? What would that mean? Then maybe one where your level of pain caused you to be off task for 5% of the day, 10% of the day, 15% of the day. And so the judge is just asking these questions to get as close to the line as possible, so that if the judge's hearing tape is reviewed, a appeals council judge or whoever's reviewing this can say, well, the judge considered all these different levels of where the pain was, all these different levels of where the knee problem, the lifting restrictions were, all these different levels of how depression impacted things. So it's really for the judge to protect him or herself and to support the decision that he or she is making. The problem, of course, is we don't know which of the hypothetical questions represents what the judge is actually thinking. That's kind of frustrating because it'd be really nice to know. But a lot of times, not always, it's the last question the judge asks or the next to last question the judge asks. And depending on how the question is asked, I can sometimes get a sense of, what the judge is really thinking. I'll give you an example. I had a hearing today where my client has irritable bowel syndrome, Crohn's disease, and had some significant other issues along with that. There's migraine headaches and some back pain and so forth. And so the judge asked a question of the vocational witness that had a lot of limitations, and then one of the limitations was that this individual would need simple work with minimal changes in the workday, with those changes being introduced very, very slowly because of problems with focus and concentration. And would that allow for transferable skills from the person's past work, which had been a skilled occupation? And in this case, my client's over 60, so if there's no transferable skills into a semi-skilled type of job, she wins. But regardless, the way the judge asked the question, the vocational witness said, well, there could be transferable skills. And the judge says, let me rephrase that. What if I said that the transition had to be very, very slow, and essentially it's unskilled work? Well, my client's past work was skilled, so there's, in that case, there was really, with the other limitations, there was no jobs the person could do, and if there was unskilled work, she would have met the grid rules anyway. But the point is, the judge saw the vocational witness was kind of wavering, so she rephrased her question to make it more limiting. And the vocational witness, based on that, said that there are no jobs, and I think we won. So the judge is going to ask these questions to kind of get a sense of where the vocational witness is going to come from, but as a practical matter, the judge is asking these questions to basically support his or her decision and give the appeals counsel reason to think the judge analyzed all the limitations and made a reasoned decision about where you fit on the spectrum in terms of limitations. Realize that I keep saying vocational witness, the appeals counsel is not going to overturn a judge because the judge made a decision that the appeals counsel disagrees with, but they will overturn a judge if it looks like the judge did not consider all of the limitations that are set forth in the evidence. So the judge is really showing the appeals counsel that he or she is considering all the limitations and kind of assigning a level or a grade to them, as it were, and made the decision based on that. So I think it's probably more CYA on the part of the judge as to why they ask so many questions, but that's really why. And I guess in theory, and I've had it happen a handful of times in 20 years, a judge, you can sort of tell, went into the questioning with one vision of what was going on, and based on the vocational witness's answer, the judge changed his or her opinion and decided, yes, this person really is disabled. But that's in theory what's going on, but again, it happens, probably 1% of the time. Normally it's just the judge confirming his or her interpretation of the evidence, but protecting him or herself from a possible review and reversal by the appeals counsel. So that's why the judge asks so many questions, and Patricia, thank you very much for the very interesting and thoughtful question. I hope you found this video helpful. If you did, I'd really appreciate it if you would give it a thumbs up on YouTube, like it on Facebook. We have a YouTube channel, subscribe to it, and also click that little bell so you'll be notified of forthcoming videos. Like our Facebook page, the Ginsburg Law Facebook page, so you can see what I'm posting there. And if you've not already done so, go to my website at ssdanswers.com. You can download for free my email delivery Secrets to Winning Social Disability Survival Kit. A lot of great information there. And if you don't have an attorney, you'd like me to review your case, there's a form on the ssdanswers.com site where I'll be happy to take a look at what you tell me about your case and give you my analysis. This is Jonathan Ginsburg, wishing you nothing but the best. Thanks a lot. Hi, this is Jonathan Ginsburg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.